Hello, members of Parliament and others who are working on improving copyright law in Kenya. My name is Mitch Stoltz. I'm a senior staff attorney at the Electronic Frontier Foundation, based in San Francisco, California, in the US. And thank you very much for allowing me to give you my thoughts about some areas to avoid as you work on improvements to the copyright law and some areas that I think you should focus on. There are two subjects I'd like to talk about. The first is some parts of the recently enacted copyright directive in the European Union, which we believe are very problematic and that we encourage you not to adopt, or at the very least to wait and see how they are implemented in Europe and what the results of that are before you consider adopting it. Those were colloquially called Articles 11 and 13 during the process. In the final version of that directive, they were known as Articles 15 and 17, or colloquially the filtering mandate and the link tax provisions, both very controversial. The third area that I'd like to speak to you about is to encourage you to consider adopting a fair use provision, a fair use exception to the copyright law in the style of the United States, Israel, and several other countries as really the important way to improve the copyright law, and I'll be speaking about that in a bit. So I understand that the amendments to the Copyright Act don't currently include provisions that are analogous to Articles 15 and 17 of the EU Copyright Directive, and I would strongly encourage you not to adopt provisions like those at this time. By way of background, both of those chapters of the EU Copyright Directive were extremely controversial, really all the way through the legislative process in the European Union. On the critical vote to include those two chapters in the Copyright Directive, which took place in March of this year, the vote was very close. The vote succeeded by only a few votes, and after the vote, a number of members of the European Parliament said that they believed their votes were counted in error and they had in fact voted against the inclusion of those provisions. Nonetheless, the provisions stand and have now been adopted as part of the final directive and must be implemented by the countries of the European Union over the next 2 years. The public outcry against those provisions was record-setting. In fact, there was a record-setting number of responses to a petition arguing against the inclusion of those provisions. So, although this did pass narrowly in Europe, it passed over the objections of millions of citizens, small businesses, and artists who thought that these provisions would be disastrous for copyright law and for their ability to communicate and speak on the internet. We'll talk a little bit about the first of those provisions. You could call it a filtering mandate. It was Article 13 throughout most of the discussions. It was Article 15 in the final directive. So good copyright law strikes a balance between upholding copyrights and promoting the benefits of digital technology. And in practice, what that means is that for internet intermediaries is that they allow rights holders to investigate copyright infringements, detect copyright infringements, and respond to them, and notify the platforms, and the platforms will then either pass on that notification or will block the infringing content. And the platforms, and here we're talking about platforms that accept user-generated content, they're held legally responsible for copyright infringement by their users only if they fail to respond to notices from the copyright holders. But the platforms are not responsible for investigating and detecting copyright infringement in the first instance. That's the legal system that has applied in most countries. It is as I understand it, the legal system that's currently being considered in the Copyright Act amendments, it was essentially the legal framework in Europe before the Copyright Directive, and it is essentially the legal framework in the United States and many other places. And it's a good legal framework because it avoids overblocking, and it allows rights holders to enforce their rights as they see fit, not empowering platforms to make determinations about copyright infringements, which is dangerous for reasons I'll discuss. Now, in some sense, it's possible to create a database of works and ownership and permissions if you're talking about a set of commercial entertainment media, which could be fairly large but doesn't nearly capture the entire universe of creativity, particularly creativity by people who aren't affiliated with large entertainment companies, cultural institutions, and so on. What that means in practice, again, is that platforms are not going to be able to identify the owner of every work that gets uploaded to their platforms, nor what permissions attach to that. But if they are held strictly liable, which Article 17 style provision would do, then they would be forced to assume as a default that anything uploaded is copyrighted by someone and has the most restrictive of permissions on it. So we've seen this in practice with sites like YouTube. YouTube has a system called Content ID attached to it, which scans uploaded works against a database of commercial entertainment built up by major movie and television producers and music producers. And even that doesn't work very well because the software is not good at really has no way of detecting whether something is a fair use or a fair dealing. It misidentifies works. It's overzealous, and it tends to take down things that that's not legally required. The problem becomes even worse when that voluntary system becomes mandatory on all internet platforms and across the entire range of copyrighted works in the world. Because while the major proponents of a law like this are major media and entertainment companies, publishing companies, and so on, they leave out the vast majority of people who use the internet, the vast majority of people creating works who won't have access to a system like that, won't be able to participate, but still may have a legal claim against the platform if the platforms are declared to be strictly liable.